Yes, Miss Ward. Some extracts from the Housing Act, Part 6 and 7. Seems like a good idea.
Yes. My Lord, not from me, although I had actually obtained copies of Section 159 myself to put up. I didn't want to.
It seems like a good idea, even if it came from Mr. Swirsky.
So, Mr. Swirsky has handed up Sections 159, 160 and 189B.
Yes.
Saving me a job, at least in relation to Section 159. For which I thank him.
Yes.
So, unless my lords would find it of assistance to be addressed on the cases in my supplementary note, may I revise my bid for time this afternoon down to 10 to 15 minutes?
Yes.
The first point I need to make is very, very briefly, just so the court isn't misled. You asked me this morning, when did my client move into his current accommodation? I'm actually told it was, can't be a precise date, but it was by the 31st of August 2023.
All right.
Not October.
August,
I
not October.
don't think it makes any difference, but
yes,
correctly recorded. Secondly, on the old cases, the note, you have my submission at paragraph 7 of that note, that there was a wider exclusion under section 21.8 of the 1948 Act, and that was not a bar to provision under section 21 of the 1948 Act on those various sets of facts where people who were eligible for, were British citizens, eligible for housing assistance in some cases, council tenants, were able to enforce a duty to accommodate them under section 21 of the 1948 Act.
Mr. Justice Scott Baker dealt with section 21.8 of the 1948 Act expressly.
Yes.
And in the other cases, the point doesn't appear to have been.
Well, in the other cases, so it's dealt with in Penfold. Penfold is then referred to in all of the others.
Right.
So it's certainly not a point that was missed. And then, of course, it's picked up again by Lady Hale in the Wahid case.
Yes.
And you've seen she then took up her own categorisation from that case in the case of M in the House of Lords. So
yes.
All I say there is that no one there, well, the fact the submission was made that in all of those cases provision ought to be made under the Housing Act, at least in Penfold, and that was rejected, and the conclusion that was reached in each of those cases was that provision was appropriately made under section 21, notwithstanding section 21. And I say there's no one has explained or sought to explain in the DOLO or to you why it's any different under the 2014 Act, which my own defendants submitted in his summary grounds of resistance. Section 23 is intended to replace section 21.8. Now, if I might very briefly go back to a DOLO for one point of substance, for which I am very grateful to Ms McGibbon for putting me straight at lunchtime. And this goes to as well the first of the sections that Mr Swirsky very helpfully has handed up, section 159, which relates to the allocation of housing accommodation under Part 6 of the 1996 Act.
Yes.
And I'd shown you the duty to have an allocation scheme and to allocate in accordance with that scheme. This section goes to what it means, what that actually means. So 1592, a local housing authority allocate housing accommodation when they do one of various things. Select a person to be a secure or introductory tenant of housing accommodation held by them. Nominate a person to be a secure or introductory tenant of housing accommodation held by another person. So that's nominate to a housing authority, to a housing association. Nominate a person to be an insured tenant of housing accommodation held by a private registered provider of social housing or registered social landlord. select a tenant to be a person on a secure contract, nominate a person to be a tenant under a secure contract. So that all goes to the allocation of the, firstly, housing stock defined in terms of who owns it, and secondly, tenure in the form of a secure or assured tenancy. So not the sort of safety net accommodation that we're talking about here. And that was, and that is, in my submission, very important to the understanding of IDOLO, in which, of course, the claimant was already a secure tenant and sought to be, well, he was a tenant of a flat owned by a housing association, but was so already had accommodation allocated under Part 6. And what he wanted, and indeed rejected quite reasonably, and no one makes any criticism of him for this, but what he had rejected other solutions, one sees at paragraph 61 to 62, that he was offered he was offered other solutions.
Sorry, Mr. Adolo or your client?
Mr. Adolo.
Right.
Paragraph, so this is paragraph 61 of Adolo.
Yes.
Page 264 of the bundle. He was offered assistance in sourcing accommodation in the private sector, which may or may not have had the potential to produce a better or swifter outcome, and advised that he could make an application as homeless, which might be a route to a quicker but temporary solution. But as he was fully entitled to do, he maintained his preferred solution to his needs, which was the allocation of a secure tenancy of a suitable property. Mm-hmm. Now, that, in my submission, goes to what it is that a local authority can be required to do under Part 6 of the Housing Act. It is allocate within the meaning of Section 159, so bring about a state of affairs in which a person becomes a secure tenant, has a permanent right of occupancy subject only to the 1985 Act grounds, of property owned by them, or an assured tenancy subject only to termination under the 1988 Act grounds, I think, of a housing association. That is not the safety net provision of providing such accommodation as is necessary to mean that Care Act services can be provided and will not be rendered effectively useless. And it goes in my submission.
Sorry, you say that's a safety net provision, but where do we get that?
The Care Act provision is a safety net.
Yes, but where do you get that label from?
But it's a label that I've used to you this morning. It's when we are talking about those to whom no other duty is owed. Nonetheless, making provision for what would otherwise be the disabled homeless, or being able to make provision for what would otherwise be the disabled homeless. Because, my Lord Justice Dingemans put to me the example of a person in secure accommodation but who wishes to be rehoused and isn't getting anywhere under Part 6. Could that person just stop paying their rent, say, well, because I'm intentionally homeless, Part 7 doesn't apply, so you have to, I mean, no duty is owed under Part 7, so you have to house me under the Care Act. Well, even if, and as I've, I hope, made clear, I don't say there will necessarily be a duty to provide accommodation, just that it is not excluded by Section 23. But even if there was a duty to provide accommodation in that circumstance, it would not be a secure tenancy, not retain all the rights associated with secure tenancy, and not, as one of my lords made the point this morning, be accompanied by the safeguards in relation to suitability. It would simply be what is necessary to ensure that the care and support needs can be met in the same way that that would be available to a disabled homeless asylum seeker, or failed asylum seeker, failed homeless asylum seeker. So ingenious as my Lord Justice Dingemans' point is, it would not improve that person's situation. It would not entitle them to something better. It would in fact leave them in a very much worse situation, even if the ruse were to pay off. But the point specifically in relation to section 159 and Idolo is that Mr. Idolo was a secure tenant. He didn't wish to give that up. He was offered accommodation, temporary accommodation in a care home under the Care Act, and also routes out through the private sector and a potential homelessness application. He chose not to pursue them because he would... I don't want to put words into, or speculate as to exactly why, but one might anticipate that he, as he was fully entitled to do, as it says at paragraph 61, did not want to give up those rights to the suitability rights and the secure tenancy rights. So that's, and I made my submission before lunch, with Idolo is a different type of case, a person who had accommodation. What Mr. Idolo wanted, which was a secure tenancy of a more suitable property, that is something that could only be provided under Part 6. What my client required which is accommodation in which his care and support needs could be met, and which was provided in the form of the local authority paying a private bedsit provider, is not something that could ever be couldn't ever be provided under Part 6, let alone be required to be provided under Part 6. It's simply a different category of, I want to say animal, which is not what it is, but it's a different category of accommodation, legal construct. It is, and I know that some of my lords have had some experience with Housing Act cases, but it is just important in my submission to hold that distinction between what Part 6 does and the allocation of relatively secure, stable tenancies, and the emergency provision of accommodation under Part 7 of the Housing Act, potentially, or under the Care Act, only in those circumstances where it's necessary to ensure that care and support needs will not otherwise be rendered ineffective, or the provision necessary to meet them will not otherwise be rendered ineffective. So, my lords, then coming to sweep up on the two grounds.
Yes.
Ground one is that it was wrong, the judge below was wrong to find that Section 23 prevented the provision of accommodation in this case. I've made my submissions on that.
Yes.
What is Section 23? It's an allocation function between public bodies. If a duty is owed under the 1996 Act, then that takes precedence. And particularly outside London, that may be of some significance because, make sure I get this the right way around, housing is a function of district councils and social services generally a function of county councils where they exist. So there may be different public bodies involved, and similarly as with Section 22 and the disputes that arise between health service bodies and local authorities, what those provisions do is sort out whose duty comes first. But there has to be a duty. And if there isn't a duty, then Section 23 doesn't operate so as to prevent a local authority providing housing in response to identified needs of care and support. Now, where that gets me in terms of ground one is that you're not simply excluded from the provision of accommodation under the Care Act where you are eligible under the Housing Act, and that's how it's put in my learned friend's skeleton argument. And on these facts, as we've said in the skeleton argument, the local authority, having recognised that there are needs that may require the provision of accommodation because they provided that accommodation, could not simply cease to provide it without having assessed properly, reflecting the case law that I've shown you, whether there was a need for it, and then made a proper care planning decision as to whether the proper response to that need was to provide accommodation pending a supported application for homeless accommodation, or anything else that it might have thought appropriate to ensure that Mr. Campbell was not left in a situation where his care needs could not be met because he did not have accommodation. What they can't do is to evade the requirement to conduct that assessment by simply relying on section 23. So that's ground one. Ground two, you have...
Ground two really say the same thing in different language. If you succeed on ground one, then you don't need ground two. If you fail on ground one, speaking for myself, I can't see how ground two can come to the rescue.
No, my lord, I agree. My submission is, in a sense, it's unnecessary. If we're right on ground one, the defendant was required to reassess before removing support. Doesn't matter what it said in the letter, the decision was unlawful anyway.
Yeah.
And the judge didn't address it because he found against us on ground one. And I don't say that he should have gone on to address it despite having found against us on ground one. What I do say is that for all the reasons that are set out in the skeleton argument, paragraphs 47 to 52, that decision on its face was based on irrelevant considerations, left out relevant ones, and on the face of the judge's finding that it was taken for the purpose of encouraging the claimant to pursue options that were available to him under the Housing Act. That wasn't a proper purpose in the context of a statutory scheme such as the Care Act, which is designed to ensure that needs for care and support are met. My lords, unless I can assist you further on any points, those are my submissions.
Thank you very much, Ms Ward. Ms McGibbon? Right, Mr Swirsky.
My lords, I'll just begin with a factual matter. I don't think it goes to anything. We just have a slight disagreement as to the dates that Mr Campbell moved out. And there were some remarks made about arrears of rent. But the situation was that he paid nothing while he occupied the property in question. There was no contract. He had no contract to pay anything to anyone. It was paid by the local authority, whether it should have been or not. That funding stopped on the 20th of February 2023 when Mr Campbell signed the tenancy agreement with Notting Hill Genesis for his current property. And as far as we're concerned, he moved into that property on the 9th of June 2023. And we say that because his uncle emailed us to say he had moved in. He's still there now. He's declined to be assessed under the Care Act since he moved. He's declined, obviously, to be assessed under for financial assessment. So he's receiving no package care in his new accommodation. The inference must be that he's continuing to receive what care he needs from his girlfriend, who is the family member who's been referred to throughout. That's the factual matter I just wanted to clear up. Turning to the judicial review, Ealing's position is that, like all local authorities, it's faced with a whole plethora of statutory duties that make demands on its time and resources. And it has duties under the Care Act, as has been identified by my learned friend. and under the Housing Act 1996, and indeed many other statutes. And what Section 23 of the Care Act does is it creates a priority between the Care Act and the Housing Act 1996 to ensure that we don't have the kind of confusion that is the subject matter of this case. Because if my learned friend's right, someone with eligible care needs, which can of course be quite moderate, but if they have 2 eligible care needs, they're entitled to Section 18 support. You have to have 2, it's not just 1, under the Regulation 2, the regulations. But if you have 2 care needs, you're entitled to Section 18 support. And in my submission, you shouldn't be able to use that as some sort of method of avoiding the provisions of the Housing Act and the various criteria that have to be met before one qualifies for or is able to get housing from a local authority. Now, I passed up sections 159 and 160 simply to show what the core responsibility is under Part 6. If I go to 159, my learned friend characterises it as a duty to have a allocation scheme in accordance with Section 166A. What we would say is that, in fact, the obligation under Section 159 is to allocate housing accommodation under the terms of Part 6. That's the duty. And so a person who is not ineligible, and I agree with the way my learned friends described eligibility for the purposes of Part 6, a person who's not ineligible because they're subject to immigration control can only obtain accommodation under Part 6 by means of the allocation scheme. And that's an obligation on a local authority to only provide accommodation in that way. And of course it's a, we would say it's a fair way of ensuring that people in the most need have the opportunity to obtain accommodation. The current section, Section 166A, is a massive simplification of the sections that were there before, that have now sections 161 following, which have all been repealed.
This was a change made in 2013.
I think you may be ahead of me there, my lord.
Well,
it's 2011.
2012.
It was 2011. Well, it was
Right.
It's the Localism Act that brought it in.
Thank you.
But I'm not sure what the start date. Yes, June 2012. And as my learned friend has said in her submissions, the current ethos of allocation schemes, sometimes called choice-based lettings, which is probably a euphemism, but it suggests that the would-be tenants have a great deal of choice about their accommodation. But within that, local authorities are required to provide a number of priorities, points to people dependent on their circumstances. And as you can see from subsection 3, we have perhaps what one would expect to find, people who are homeless get a lot of points. People occupying in sanitary or overcrowded housing or unsatisfactory housing conditions. And at D, people who need to move on medical or welfare grounds, including any grounds relating to disability. There's inevitably going to be a significant overlap between section 166A(3)(d) and people who need care and support under the Care Act. But in order for them to obtain accommodation under the allocation scheme, they're going to have to follow the scheme, for which they'll be given additional points because of their disability. And of course, Mr. Campbell was in band B, it's the second highest band, and eventually he did obtain accommodation through Part 6. That was saying it's as simple as that, how Part 6 works, and it's tied into Part 7, as one can see from subsection 3A, because one of the ways that a local authority can discharge a homelessness duty is by providing accommodation out of its own housing stock. We don't have section 206 in front of us, my lords, but that is the section in Part 7 which lists the ways that a local authority can discharge its duty to the homeless. And that the ways that it can be done is by securing that suitable accommodation provided by them is available, securing that he, that is, a homeless person, obtains suitable accommodation from some other person, or C, by giving him such advice and assistance as will secure that suitable accommodation is available from some other person. C is probably not very useful to most homeless persons, so it comes down to A or B. A is effectively Part 6. B could be Part 6 if it's from a housing association, or it could be in the private sector if a local authority is able to identify somewhere in the private sector that person to move to. So Part 6 and Part 7 are interconnected, and I do want to say something about how Part 7 works. My learned friend has taken you to this. I want to start with the core duty. It's at section 193, it's page 44 of tab 2. This is sometimes called the full housing duty.
Yes.
So, a local authority, when faced with a homeless applicant, or potentially homeless applicant, has to make statutory inquiries, which are covered by section 184, which you were taken to this morning. Once it makes those inquiries, it can provide temporary accommodation. But the full duty arises that when a local authority is satisfied that an applicant is homeless, that's section 175, and eligible for assistance, that's section 185, and are not satisfied that the applicant has become homeless intentionally, which is section 191, the authority are also satisfied that the applicant has a priority need, that's section 189, and this is why have the last passage passed up to you this afternoon, the last section, which is section 189B. The authority's duty to the applicant under section 189B2 has come to an end. If I can just take you to that section, my lords.
Sorry, section
189B, big B. It's the last of the three sections. And this is a later amendment, obviously, as a result of the Homelessness Reduction Act 2017. This section applies where the local housing authority is satisfied that an applicant is A, homeless, and B, eligible for assistance. Subsection 2. Unless the authority refer the application to another local housing authority in England, the authority must take reasonable steps to help the applicant to secure that suitable accommodation becomes available for the applicant's occupation for at least A, 6 months, or B, such longer period not exceeding 12 months as may be prescribed. And so, at an early stage, once the inquiries as to homelessness and eligibility for assistance have been concluded, a local authority is obliged to provide short-term accommodation to ensure that a homelessness applicant is not street homeless. And this provision clearly complements section 188, which is an interim duty to accommodate in case of apparent priority need. This is at page 37, the authority bundle after tab 2. Subsection 1. If the local housing authority have reason to believe that an applicant may be homeless, eligible for assistance, and have a priority need, they must secure that accommodation is made available for the applicant's occupation. That's an interim duty until a decision is made on full duty. So the effect of these two sections, in my submission, is that if someone presents to the local housing authority as homeless, provided they can establish that they're eligible in the sense that they are not subject to immigration control, they're entitled to the short-term accommodation under section 189B, big B. And if they appear to be in priority need, they're entitled to an interim duty under section 188. What that should mean is that no one who makes an application as a homeless person should be street homeless, and certainly not someone who is an apparent priority need if they have some eligible, which they're likely to be, if they have some eligible need for care and support. I remind your lordships of the meaning of priority need. It's at page 40 of tab 2. It is a person who's vulnerable, in this case, I mean, there are other categories, pregnant woman, person with dependent children, a person who's vulnerable as a result of old age, mental illness or handicap or physical disability or other special reason, or with whom a person resides or might reasonably be expected to reside. And this subsection has been the subject of a great deal of litigation over the years. It was considered by the Supreme Court in a case called Hotak in the London Borough of Southwark, which I mentioned at paragraph 42 of my skeleton on page 54 of the core bundle. It was decided that this case didn't need to go into the authorities bundle because there was no dispute about it. But the Supreme Court concluded that a person would be vulnerable for the purpose of the statute if they'd be significantly more vulnerable than an ordinary person if made homeless, or more at risk of harm without accommodation than an ordinary person would be.
Sorry, in your skeleton, that's...
Paragraph 42, right, page 54 of the core bundle.
Yes.
So, the homelessness legislation, Part 7, has been described in the past as a self-contained code for dealing with homeless persons. And in its current iteration, it gives a degree of protection to anyone who is street homeless, and that accommodation will be provided in the short term, pending the determination of whether a housing duty is owed. And if the duty is owed, then it has to be discharged in one of the ways set out in section 206. There are, as one of your lordships said this morning, a number of checks and balances within Part 7. There is the right at more than one point during the process to seek a review. If someone's offered accommodation in discharge of the full housing duty, it's open to that person under section 202 to seek a review of the offer if they don't think it is a suitable property to discharge the duty. There's also a provision to seek a review of any temporary accommodation that's offered, again on grounds of suitability. With regard to the discharge of the full duty, if a person is unhappy with the review, under section 204, they can apply to the county court appeal to the county court, I should have said, on a point of law. And the section 204 appeal is analogous to judicial review in the county court. It's the same tests appear routinely applied. The relief is discretionary. The relief that's granted is generally quashing a decision that is found to be unlawful. Allied to that, there's section 204 big A, which gives a homeless person who is appealing the right to seek interim accommodation pending the outcome of the appeal. So there's a whole architecture of checks and balances. But of course, it works both ways, because an applicant has to accept accommodation that is deemed to be suitable. If after review it's still held to be suitable, otherwise they lose the right to housing. And of course, people who've made themselves intentionally homeless are owed a lesser duty than the full housing duty in section 193. So there is a well-constructed, well-thought-out code that enables homeless persons to obtain accommodation from the state in this way. What we say is that if someone is homeless and is looking for ordinary accommodation as opposed to accommodation in a residential care home or extra care or some form of assisted living, the way they obtain that accommodation is via Part 7 of the Housing Act. Now it's right, I have to accept that throughout Part 7 such a person is referred to as an applicant. Now it may be that those who drafted the statute couldn't believe that a homeless person would not make an who wanted to be accommodated by the local authority would not apply that accommodation. But in my submission, it can't be right that someone can do what Mr. Campbell did, which is, and you'll have seen from the statement in the supplementary bundle from Ms. Yusuf, that he, on 3 occasions, applied for as a homeless person, but withdrew his application because he feared that he wouldn't get a secure tenancy from the local authority, and he didn't want to be accommodated in the private sector. And it simply can't be right, we say, that someone can do that and say, well, you've got to accommodate me under the Care Act by some sort of back door as a safety net, because I want a certain kind of tenure and I don't want to go into the private sector. Because that would put people with eligible needs at a significant advantage over all kinds of other persons who might be in priority need as far as Part 7 is concerned. For example, a young mother with small children, someone with mental health problems who didn't have any eligible needs. If Parliament had intended people with eligible needs under the Care Act to be put into a specific and special kind of category, in my submission, it would somewhere in the Housing Act it would say so.
Or I suppose who had only one eligible need, however serious. If you have to have 2.
As it's possible. Oh. But if you have one eligible need, no matter how serious, you're almost inevitably going to fall into the priority need category of...
Yes, no, I was giving that as an example of a person who would be, as it were, queue-jumped by somebody who has 2 eligible needs.
But of course, the other point we've made is that it would be strange if Parliament had created this architecture for dealing with homeless persons. And in fact, a similar or different architecture under the Care Act for assessments and meeting those, the needs identified in the assessment. But at the same time left the question of ordinary accommodation for people with eligible needs unmentioned, without any checks or balances, without any statutory procedures that had to be followed. And that someone like Mr. Campbell, with the support of my learned friends, could come and say, well, I don't fall within the Housing Act because I never made an application, I didn't make an application that was relevant, and therefore I should be treated differently from other homeless persons.
Can I just ask something on the actual factual position? I think when you corrected what you said was a sort of a dispute between you and the applicants, you said that there were funding for the payment of his bed and breakfast accommodation before he moved to his flat stopped on the 20th of February 23, is that right?
Yeah.
So, because the decision letter withdraws funding on the 25th of April 2022.
Yes.
But it just carried on being paid.
Well, it was agreed once. I'm not sure if it was agreed at the point of issue or at the point of the letter before claim, but we agreed to keep funding it pending the outcome of the judicial review.
Yes, and London Defendant's absolutely right just to say that the pre-action correspondence is at the back of the supplementary bundle, and one can see the agreements to keep funding in response to that correspondence, and then once the claim is issued. I don't think it was interim relief as such. I think it was agreed.
No, it doesn't seem to have been interim relief, but I hadn't got the date on which. All right, thank you.
So it was agreed throughout.
And just to say, while I'm on my feet, my learned friend corrected me about the date on which my client moved. We understood it was sometime between the 2nd of June and the 31st of August. We're absolutely content that it was the 9th of June.
All right, okay, that's fine. The point then is that this, if Ms Ward is right in her analysis that you can, as long as you've got accommodation, no matter how inadequate it is, to discharge the care needs. In fact, until February 2023, his care needs were being discharged at accommodation that you were funding anyway. I mean, that doesn't necessarily make the decision unlawful, but just as a matter of practical reality.
That was the reality, because
Yeah.
we sent the letter early 22. It immediately produced the letter before claim.
Yeah.
It was never our intention that he would be street homeless, and so I'm not going to go into the advice that was given, but the fact is it was funded, I think initially until, I can't remember, but I think initially until permission, and then when permission was granted until the conclusion, and then after the conclusion a period was agreed and to find something else.
I don't think it deals with the point of principle, but it just means that in practice there was accommodation plus until the 20th of February.
Well, there was accommodation, but the local authority never provided any plus in this case.
Because it was always being supplied by family.
Insofar as anything was supplied, it was supplied by the girlfriend.
Yeah.
At one stage, I think, to be strictly accurate, she said she was going to stop, but she never did. And
So there's a reference to someone being in prison for a period of time and the family stepping in, but whether that was the girlfriend or
no, it wasn't the girlfriend who was in prison. I think they had I don't want to stress.
So anyway, it doesn't matter.
She was going to stop, but then she didn't, and so it just carried on. So I think I got as far as saying that we say section Part 7 provides a complete code for dealing with the homeless that gives the correct priority as decreed by Parliament to persons with medical conditions. And that the effect of section 23 is that if you qualify, if you're homeless and you can make an application under Part 7, then the local authority should not be providing you accommodation under the Care Act. It may not be.
Well, you say presumably that the words required to do under the Housing Act mean required to comply with the provisions of Part 6 and 7.
I do. Yes.
And that answers the whole case, if that's the right construction.
That answers the whole case, as your Lordship says. And if it doesn't mean that, then the reference to the Housing Act 1996 doesn't really mean anything. One would expect, if this provision, which is a third of 3 exclusionary provisions, where first you have the immigration control, which is a political matter, but then you have the, as it were, the bright line between the NHS and adult social care, which of course is an issue that in different contexts causes its own fair share of judicial reviews. And here you have the line being drawn between housing and adult social care. And while we have the cases that your Lordships have been taken to this morning, where, for instance, in Burris, where the term accommodation plus was invented by Ms Malik, is that these cases all concern people who do not have any rights under the Housing Act because they are subject to immigration control, but still have eligible needs, and they will, in the colourful phrase that my friend used this morning, which I can't remember, from Lord Justice Simon Brown, at least people who are living on the street from abroad will not be the sick and the infirm.
Well, if someone is subject to immigration control, doesn't the Housing Act require local authorities not to provide them with accommodation?
Exactly, and that's why, because they're subject to immigration control, they're not caught by Section 23. And
there are other mechanisms which may be available to assist them.
Well, yes, but ultimately local authorities do have to pick up those people because Section 17 of the Children Act, for example, has been construed as requiring in certain circumstances local authorities to provide support to the families of failed asylum seekers who wouldn't otherwise qualify for assistance.
Okay.
But those are the exceptions to section.
Yes.
They're like, yes, well, the exceptions to the exception. People subject to immigration control are not caught by section 23, and so they can, if they have eligible needs, which can amount to accommodation plus, the local authority may be obliged to accommodate them. And likewise, it might be said that someone who, for whatever reason, has excluded themselves from the provisions of Part 7, but has profound needs for care and support, would not then be excluded by Section 23, and a local authority might have to accommodate them as a matter of last resort. I don't want to try to give examples. These matters are on a case-by-case basis. But as far as the general scheme is concerned, persons who are not subject to immigration control, if they're homeless, they're covered by Part 7 and not by the Care Act. And we find support from that when one looks at the old authorities, which my learned friend in the end didn't have time to take you to. But if I can just take you to the last one of the authorities at the back of note on predecessor legislation, which is the case of Wahid and Tower Hamlets. It's a decision of this court. And the facts were that Mr. Wahid suffered from schizophrenia, was receiving aftercare services under Section 117 of the Mental Health Act 1983, and he sought accommodation under the National Assistance Act. Now, on the facts, his claim was rejected by this court. But if I take you to paragraph 34, which is at the back of the small sheet of documents that my learned friends provided, Lady Justice Hale said this. Sorry, before I read it out, I should just stress that in this case, Penfold and Tantu were both cited to the Court of Appeal. So her ladyship said this: that's sufficient to decide this appeal. Had it been that the combination of the claimant's mental health and a severe housing problem gave rise to a need for care and attention, this claim would still have faced considerable difficulties. He would have had to show that the care and attention he required was not otherwise available to him. He would have also had to surmount the hurdle presented by Section 21(8). Nothing in Section 21 allows, let alone requires, a local social services authority to make any provision authorised or required to be made, whether by them or by any other authority, by or under any enactment other than Part 3 of the 1948 Act. The asylum seekers, referring to some of those other cases cited here, succeeded because there was no other power, let alone duty, to provide them with the care needed to sustain life and health. there is power to meet ordinary housing needs, either through the procedures for allocating social housing under Part 6 of the Housing Act 1996, or through the provisions for assisting and accommodating the homeless under Part 7 of that Act. Even if you were able to surmount all those hurdles, the local authority would then have to consider how to meet the need identified under Section 1. Stop there. So, and I accept this is obitur because the first sentence of that paragraph makes it clear that it is. What her ladyship is clearly saying is that under the 1948 Act, if you were eligible, and I'm going to use that word mutually, under Part 6 or Part 7, you weren't going to be able to get yourself accommodation under Section 21, or you're going to face formidable hurdles. And of course, Lady Justice Hales, she then became Baroness Hale, sat in the House of Lords in the case of Eamon Slough, where the case of Wahid was cited to their lordships, and she gave the judgment that both my learned friend and I have referred to in our skeletons. So it's reasonable to assume that she would have been aware of that passage when giving the judgment in Eamon Slough. So if that was the position prior to the enactment of the Care Act 2014, one would expect that it to be the same afterwards, unless there was a very good reason for it not to be. And if one looks at Section 23, we say that this is just a modernised modernisation of Section 21.8. It's slightly more prescriptive insofar as it doesn't just say any other enactment. It's the Housing Act 1996 or any other enactment specified in regulations. But it's still, we say, the natural successor of the old Section 21.8.
So what do you say the answer to Miss Ward's reliance on Penfold is?
Well, I suppose for me the simple answer is that Penfold was wrong insofar as that argument wasn't put to his lordship in Penfold. Penfold was certainly cited to the Court of Appeal in Wahid,
yep.
And Wahid was cited to the House of Lords in M. And of course, if one looks at Penfold, the issue in that case was whether or not Bristol City Council had carried out an assessment, or whether they had a discretion whether or not to carry out an assessment. They hadn't carried out that assessment. And if one looks at page 29, where his lordship sets out his conclusions, the first conclusion is that the respondent never conducted an assessment at all, And of course, the relief was that the council was directed to carry out an assessment. What His Lordship does go on to say at conclusion 3, the local authority has, following a community care assessment, power to provide accommodation under section 21. Normal housing can be provided when it would otherwise have to be met by other community care providers. But that is difficult to reconcile with the words of section 21.8 itself, which appears to say that something rather to the contrary, that nothing in this section will require a local authority to make housing provision under another where there is a requirement under another statutory provision for housing provision to be made.
Well, it was argued at page 24, letter H, that it, on behalf of the applicant, that it was 21.1 could give accommodation, albeit only as a fallback.
Yeah. But I believe His Lordship rejected that argument.
It's at the top of page 26.
Yeah. Well, yes, perhaps that is the answer. He says it's a safety net, and it can provide normal housing when it's the answer to a need which would otherwise have to be met by other community care services. But if that's the basis of his decision, then it's very different to the facts of this case, which is not the need in this case is pure housing. The other needs are being dealt with by the girlfriend, and the only matter which the claimant is really troubling the local authority and indeed the court is the question of housing. It is a sort of housing or nothing situation. So perhaps I should then turn to Idolo. Though in a sense, my submission so far really been a synthesis of what Ms. Collins-Rice, as she then was, said in that case.
Yes. Well, if you want to say she got it right, there's nothing more to say, and we should approve it. By all means do, if if you think there's anything else.
No, I'm quite happy to say that, my lord. You're quite right. You can all read what she said.
Yes.
But what I do want to say is that the argument for Mr. Adolo was not put on some narrow basis that because he was already in accommodation, that put him in some sort of special category. As you can see from paragraph 45, the construction of section 23 in general terms was front and centre in that case. But beyond that, I will adopt what my Lord Justice Bean has suggested about Adolo. And so, my lords, that really is it on ground one as far as local authority is concerned. We say it's quite clear what the intention is, but what the parliamentary intention is that if you're homeless, you are dealt with under Part 7 by a local authority's housing department. If you're in need of care, you're dealt with by the adult social care department. And a line has to be drawn somewhere between them. Of course, adult social care does involve some accommodation decisions. Social workers are always having to decide whether an elderly or infirm person should be able to remain in their own home. I mean, you may need to make an application to the Court of Protection about that, but that's an accommodation type issue. Whether they'd be better off in some form of supported living, whether they'd be better off in a residential care home. But those are social work decisions which are properly made by social workers. They're not housing decisions that are properly made by housing officers. And while, of course, there is only one local authority in the sense of London Borough, like Ealing, like all London boroughs, it's divided into different departments that have different specialities where people are employed specifically to deal with particular issues and to ensure that the limited resources that are available to a local authority are allocated correctly. And what can't be included in that, or shouldn't be included in that, is providing free accommodation to someone who could be accommodated in ordinary housing, could apply for housing benefit, just like anyone else who approaches a local authority. And who should enter into an ordinary tenancy agreement with someone where both parties have the obligations that one would expect in a tenancy agreement, the security of tenure, the right to have repairs done, the obligation to pay rent, the obligation not to cause a nuisance or commit acts of waste. It is, in our submission, strange. It would be strange if my learned friends are right and that a local authority can find itself in a position of accommodating someone indefinitely on no proper contractual or statutory basis for free. Now, of course, Ealing accepts that it got itself into this situation to a large extent, but that of itself doesn't mean that it's obliged to accommodate Mr. Campbell in the way suggested. In any event, those are our submissions on ground 1, unless there's anything you wish me to deal with. As far as ground 2 is concerned, the irrationality part of it really just follows on from ground 1. Safe to say that we would say that one could be wrong on the law without being irrational. It's a different test, and really it adds very little to ground 1, which is the real issue here. As for the ulterior motive, or the improper motive, we rely on what's said by the learned judge at first instance. He found there was no improper motive, and that he felt obliged to accept the evidence of the local authority witnesses who were not called upon to be cross-examined and challenged on their witness statements. So, my lords, unless there are any other matters you wish me to deal with, those are my submissions.
Thank you very much, Mr. Swarthy. Ms Ward, as ever, no need to repeat anything, but if there's anything you feel you need to reply on, then please do.
4 points very briefly. Firstly, just in response to my learned friend's last point about the witness evidence, of course the submission on improper purpose in the skeleton argument is made on the basis of the judge's finding, accepting the witness evidence as to what the purpose was, so there's no suggestion that that isn't the basis on which this court should operate. Turning then to points of some more substance, my learned friend addressed you on Penfold, which I didn't, and I don't want to take up a huge amount of the court's time on this. I make points I wanted to make at paragraph 4 of the note that we put in yesterday, but the page references there were based on the law report rather than the bundle, so it may help just to take my lords to those pages. So as I say there at paragraph 4, Mr Justice Scott Baker rejected an argument specifically put in these terms that section 21.8 prevented the local authority from providing housing under section 21A because it failed to be dealt with as a discrete function under what was then the Housing Act 1985. And the reference I give there is 325 H to I. The reference in the bundle is, one moment, so on page 24, beginning at letter H, where the claimant's submission is set out, Mr Gordon argued that section 21.1 especially enabled the authority to provide accommodation in certain circumstances, albeit only as a fallback provision. To this, Mr McLaren, for the defendant, local authority there, had two answers, and it was the County Council, the Adult Social Services Authority that was the defendant there, said, first of all, what the applicant is seeking is normal housing, that is to be rehoused in a house of her own choice in a location selected by her. This is something that falls to be dealt with as a discrete function by a housing authority under the relevant legislation, namely as it then was the Housing Act 1985. Mr Gordon's answer to that point is that normal housing can be provided, this is at J, under the National Assistance Act when it's a function of need, which would otherwise have to be met by other community care services. And it's Mr Gordon's submission that is accepted at the top of page 26, where he says, in my judgment, while section 21.1a is not a basic safety net for everybody, and I think in answer to my Lord Justice Bean's question earlier, that may be where I got the term safety net from.
Yes, it may.
It can, in appropriate circumstances, extend to the provision of normal accommodation, can be provided by this subsection when it is the answer to a need which would otherwise have to be met by other community care services. And in this case, what the applicant was saying, and one sees this on page 14, not achieved this via the Housing Act 1985. The Respondent Authority had lawfully concluded, this is at page 14, just above letter F, it discharged its duty to her under Part 3 of the Housing Act, which is the homelessness provision. And in the next paragraph, She was offered accommodation under the ordinary waiting list, so the Part 6 equivalent, rejected on the grounds that her daughter would be at risk at that area, needed to be near her family in central Bristol. Her appeal was rejected, so she was clearly eligible under the then Housing Act provisions, had exhausted them, and what she sought then was an assessment under the patchwork provisions, including, which could give rise to a duty under Section 21 of the 1948 Act, with a view to being provided with accommodation within central Bristol. The defence to that was, well, we can't give you that under Section 21 because of Section 21.8, and that was rejected in terms. As well, the defence says the net result was that an assessment was ordered. That's because the assessment had been refused.
Sorry, I thought they'd rejected it because they said they didn't have the resources.
Well, that was one of them.
And then actually didn't carry out any assessment at all.
Yes. But they rejected it on that ground. That was one of the issues before the court. But they also contended, and this is at 14J, as well as the passage that I've shown you, contended it had no power to provide normal housing under Section 21 because of 21.8, which restricts the power to provide normal housing to provision under the Housing Act 1985. And this in circumstances, as I say, where the applicant had pursued the Housing Act 1985 route and been turned down. And all she was seeking was accommodation near her family in central Bristol, so that they could continue to provide the social care services for her.
I'm a bit puzzled by what the judge had in mind in the passage at the top of page 26, which you cite, when the test seems to be that you can provide normal housing when it's the answer to a need which would otherwise have to be met by other community care services. Well, if you could meet the need by other community care services, why wouldn't you? And it comes immediately after an example at the bottom of 25 of a person who needs to live next door to a drug rehabilitation centre, and the submission is that provision of accommodation could in such circumstances be a function of meeting such a person's care needs. Well, why wouldn't you pay for a bus ticket or a taxi ride, or even take somebody with him to the drug rehabilitation centre, which is going to be much more straightforward than providing accommodation, which we know that councils struggle to do. So I just struggle a bit to see how this would work in practice.
Well, firstly, I can't speak for the example that Mr. Gordon gave to the court in 1998, and I know very little about drug rehabilitation services now, let alone then, and why there might be a need to be close by, for example, for easy access to counsellors. I don't know. I simply don't know. What this case was about the applicant relying on her family for the provision of what would otherwise be social care needs, and therefore if she had to move away from them, there being a social care need to potentially those services being currently provided by the family to be provided by social services, because she wouldn't be near them anymore and they couldn't pop in and make sure that she had dressed herself or whatever it was. So that was that context. In my submission, that's really, bearing in mind that these are before the series of cases that consider what care and attention means in detail, that's really a forerunner of accommodation plus. It's saying that if you need the accommodation in order that your social care needs are met,
yes, although
then normal housing can be provided.
The judge didn't think there was much chance of her succeeding there.
No. And on the facts, that's perhaps not surprising in the services. But all that was sought in that case, which again has some similarities to this, was an assessment of whether that was the case, of whether those needs that were identified that exist could be met if the housing wasn't provided. And what Penfold decided in terms was that wasn't excluded by Section 21.8, so effectively there wasn't no point in the assessment, there wasn't an absolute bar on accommodation being provided under that provision. So that's why what I say the accepted position was under the predecessor legislation. Penfold.
Well, if that's right, then Idolo is completely wrong. And this case mysteriously wasn't cited in, for example, M and Slough. I just had a look. Why not?
Well, my lords, it wouldn't have been relevant in M and Slough because the 21.8 wasn't relevant in M and Slough because you're talking about people who are subject to immigration control. So it only gets cited in Idolo, well, so it doesn't get cited, but the issue only comes up when the Section 23 point is taken. Now, Section 23, as we know, is the successor to Section 21.8. It's on its face narrower. Now, it's narrower in two ways. One is that it refers specifically to the Housing Act rather than any other legislation. I suspect there are two reasons for that. One is that Section 21 was concerned only with the provision of accommodation, whereas Section 23 is a general exclusion in relation to provision to meet needs for care and support. So it makes sense to identify the legislation you're concerned with. Secondly, of course, it is enacted in the face of the Localism Act, Section 1, and the general power of competence. So it makes sense, again, to restrict it to the Housing Act. That, I don't think, matters particularly for these purposes because we are concerned with the Housing Act. The other way in which it's narrower is that Section 21.8 referred to anything that was authorised or required under any other enactment. Section 23 terminology is only required. So it is, if anything, narrower in that sense. Something might, I don't say is, but might, one can imagine, be authorised under the Housing Act. So are powers, but not required in the sense of being a duty. So what we're concerned with are what are the Housing Act duties. And I'll move on, touch on that very briefly in a moment under my second point. But still on the first point, this decision in Penfold, Mr Justice Scott Baker, is followed by Mr Justice Enriquez in Batantu. Both are cited to the Court of Appeal in Wahid with no disapproval.
Can we just look at that? Have we got Wahid?
We have Wahid, yes. It's the final final item in that bundle, begins on page 66. So one sees at H3 on page 66 specifically that Batantu and Penfold were cited for that proposition, that the accommodation which may be provided under Section 21 is not limited to any specific kind of accommodation, may include various types of housing, including ordinary housing.
It's not quite the same point.
It's not quite the same point, but the cases are there. So the point is addressed in Penfold. It's not addressed as part of ratio anywhere else, and indeed it's not addressed conclusively in Lady Hale's obiter dicta in Wahid. She simply refers to it as what Malone friend showed me the passage, as a hurdle that would have to be overcome, but there's no exploration of the circumstances in which it would arise. The only case in which that is faced up to squarely in Section 21.8 is looked at is Penfold. As I say, there's no suggestion in any of the other cases that Penfold was wrongly decided. So I say it does, at the very least, support my point, and my lord is right that it conflicts with Idolo. You know that in Idolo, the judge said that there was no authority identified on Section 23, which of course is technically correct because these are not Section 23 cases, but they are cases on the forerunner, the predecessor legislation, and it doesn't appear they were cited. So
it looks as though Penfold was referred to in Wahid at page 71, paragraph 18, by Lord Justice Bill, I think it is, giving the lead judgment, where he sets out the bit that you've relied on, and then that's repeated in Batantu. And then over the page at paragraph 20, it looks as though it was conceded that the expression residential accommodation in section 21 can mean ordinary accommodation, so it's not a decision of the court,
No, I don't.
but conceded.
I don't.
And then he goes on to say in paragraph 21 that need for care and attention remains a precondition if Mr Justice Scott Baker was holding otherwise, then I respectfully disagree. And then again, Lady Justice Hale at 31 records that, records the fact that it was common ground.
Yes.
Yeah.
Yes. So it was common ground in that case that Penfold was rightly decided. There's no suggestion that it was wrongly decided. The only, my Lord rightly drew attention to the Lord Justice Peel's sentence, if Mr Justice Scott Baker was holding otherwise, and that was if he was holding otherwise, then the need for care and attention remains a precondition to the arising of the duty. Well, I don't suggest that that's wrong. I mean, in fact, I have submitted to you at quite tedious length that the need for care and attention may give rise, is a precondition to the arising of a duty to accommodate. And that's why I said that
Yes, it may suggest that Lord Justice Peel detected some lack of clarity in what Penfold did decide on that. Perhaps.
may, but it's certainly not disapproved. It's before the court, and there's no decision that either it or Batantu was wrongly decided. And there is also the Bernard case. I accept at first instance, and I don't again wish to detain your lordships unnecessarily on these cases, but it was as I said when I took your lordships to Adolu, Mr Justice Collins Rice in Adolu referred to Bernard, described it as a case about a housing duty. One sees on page 40, the Supplementary Authorities bundle, the first page of Bernard, just between H4 and H5, the defendant in that case conceded that it did owe a duty to the claimants under section 21, albeit only on the eve of the hearing. What then happens is that an order is made by consent. Yeah, so on page 48, paragraph 16 towards the bottom of that page, at the hearing the council formally conceded through counsel that it did indeed owe a duty to the claimants under section 21, and at the substantive hearing on March 27th there was an order largely by consent about the defendant providing accommodation for the claimants by a two-stage process. And you see over the page, paragraph 19 on page 49, that in chasing correspondence seeking to enforce that, have that order complied with, the claimant solicitors included the threat to make an application for an order requiring the defendant to show cause why its director of social services should not be committed for contempt. So it was very much a social services case, and albeit accepted, and I say accepted because of the line of authority that no one saw fit to doubt that this was, that this could be provided under section 21, that section 21.8 was not such a bar. So that's those cases. Two other points, if I may. Just briefly, firstly, my learned friend said at one stage that it might be right that local authorities would have to accommodate even disabled, not subject to immigration control, homeless people as a matter of last resort on a case-by-case basis. Now, if that is a suggestion that they would do so, for example, to prevent a breach of the Human Rights Act, then of course, if he's right on his construction of section 23, that wouldn't assist, because under the Human Rights Act, it doesn't enable a public body to act in a way that is prohibited by primary legislation. So he really is setting up a situation in which there is no potential recourse for a profoundly disabled person who's been found to be intentionally homeless. And that is the the end point of where his submission takes you, and the Human Rights Act can't, if he's right on Section 23, help you with that. It may be on, there's no Human Rights Act point run in this case on different facts. There may be an interpretation point to be run under the Human Rights Act, but I'm not running that point. I'm simply saying that Section 23 should be read at face value, and that it only bites, its only role is to delineate responsibilities as between public bodies, not to shut individuals who have needs out of provision being made to meet those needs. Now, just to finish a few sub-points within that point, yes, that puts people who have needs that require care and support under the Care Act in a separate category, to the extent that provision is made for them in the Care Act, in the same way as the infirm asylum seekers are in a separate category to the able-bodied, because of the safety net provision in the Care Act. It's not an exception to the Housing Act. It's a safety net provision, not the provision of long-term stable accommodation subject to a secure tenancy in the stock of housing that's available for allocation under Part 6. And not even the provision of accommodation under Part 7 with the suitability tests and the rights of appeal there, but a safety net to ensure that there are not disabled people sleeping on the streets. That's all it is. It won't be very many cases. It will be some. And the other sub-point within this is that my own friend referred to local authorities having to accommodate people such as my client indefinitely. That is not the submission that we make or ever have made. The original grounds for judicial review at a time when Section 23 had never been raised, where that you can't withdraw support without reassessing. Nothing particularly controversial there. All we say now is that an assessment is needed of whether he has needs that cannot be met unless he has accommodation. If that's
but
right.
If the answer is yes.
If the answer is yes, then the local authority
he has to be provided with accommodation unless his health miraculously improves for an indefinite period.
My Lord, as we've set out in the skeleton argument, and I'll just make sure that you have the reference to that paragraph. Again, it's paragraph 32. I just want to make doubly sure. 42, page 34 of the core bundle. The care plan might in principle make provision that the appellant's accommodation plus needs should be met by an application for homelessness assistance pursuant to Part 7, subject to usual safeguards, for example, consideration as to what happens if it transpires that main housing duty is not owed. But of course, as part of that process, he would have the support of services such as an advocate to ensure he understood the consequences of withdrawing an application. It may be that a care plan could provide that he will be supported to bid on properties, and if he doesn't do that, then the local authority's duty will at some stage be discharged. It's not an open-ended, you will have to provide accommodation forever and ever. It's a how can the need for accommodation be met?
Right.
And
I don't understand why it wouldn't be open-ended, if you're right. I mean, it once in accommodation provided for the purposes of care and support under the Care Act, wouldn't he then be in a similar position to Mr. Idolo in saying, I don't want 6 months temporary accommodation for the homeless, why should I? I'd rather stay put, thank you very much.
Well,
then what?
No, because if the care plan provides that he will be supported with the application and he doesn't, there does come a stage when even the local authority's duties are discharged. And there's a case, Tim, that we haven't put in, but actually precisely on that point about providing accommodation under section 21, and then that duty will be discharged because of the, in that case, it was antisocial behaviour. But local authorities have to consider how best to meet the needs and have to put a care plan in place that is likely to meet those needs, or is designed to meet those needs. And of course, with the fallback for how accommodation, but ultimately, duty can be discharged by making that provision as set out in the care plan. If that was a lawful decision in the discharge of the local authority's duties, then it can't be required to do any more. In this case, it hasn't done that.
Right.
Well, may I just turn my back for 1 moment to make
Of
sure I
course.
haven't missed anything? My Lords, Ms McGibbon does have a point she wishes to make. I appreciate slightly unorthodox in reply, but it is a reply point. I can
all
take
right.
a note and read it.
We may then need to hear from Mr. Swirsky, but go on, Miss McGibbon, if you've got the point, then rise to your feet and tell us what it is.
Apologies, my lord.
That's all right.
It's a short but very simple but potentially important point about the case of Idolo, and I'm sorry to take you back to it. But if I could turn you to page 264 of the authorities page. Again, for which my apologies. And it's at paragraph 63. I apologise that the sideline doesn't extend all the way down to it, but it's only in...
It's all right, we'll find it. Paragraph 63.
Of Idolo, at
Yes.
264 of the authorities bundle. And this is the original authorities bundle, my lord.
Yes.
The final sentence of that paragraph records that possible short-term interim solutions were looked at, including a temporary care home placement, but either they offered no great prospect of success or involved the separation of the family, which Mr. Idolo declined, as he was entitled to do. Now, that indicates in my submission that the local authority in this case, the London Borough of Bromley, had concluded that Section 23 was not a bar, in that case, to the provision of accommodation to Mr. Idolo under the Care Act, and the reason for the outcome in Idolo was that that had been offered and declined. So clearly in my submission the authority had formed a view, we say rightly, that Section 23 was not a bar, and the reason for that was that all that the authority was required to do under Part 6 of the Housing Act, as my learned leader has set out, was to operate a scheme for allocation of social housing, so secure tenancies with local authorities or registered social housing providers. Now, what Mr. Idolo wanted was a secure tenancy, and that could only be done by under Part 6, so it couldn't be done under the Care Act because of Section 23, because that would have required the authority to do something, allocate social housing, which they were required to do in accordance with Part 6. So in my submission, the fact that the local authority had offered that provision under the Care Act not only confirms that they had not considered the fact that he was eligible under Part 6 to be a bar to the provision of accommodation to meet where it was necessary to meet needs under the Care Act. But also that was critical to the outcome, the fact that it had been offered and declined. And the shorter point, my learned friends already referred to paragraph 61, just above, which was that Mr. Idolo had been advised that he could potentially make an application as homeless. He was a person who was eligible in the immigration sense, and there is also it's discussed in more detail elsewhere in the judgment. That's at paragraph 29, page 257. The discussions around the possibility of him applying as homeless and his reasons for not doing so. So to that extent, he's in the same position as our client, that he'd elected not to make an application and make the same submission. That was not a bar. That was not considered by the local authority to be a bar to the offer of accommodation, which was made and is recorded at the paragraph to which I took the court a moment ago, paragraph 63. And so in my submission, Mr. Idolo is precisely the kind of person whom this safety net might assist, and it records that he was offered that.
How do we know that the possible short-term interim solutions referred to in paragraph 63 were offered under the Care Act as distinct from the Housing Act, when it looks from paragraph 61, which also speaks about them, as though they were offered under the Housing Act?
There's two reasons I say that, my lord. The first is that this is a temporary care home placement. So in this instance, it's not the kind of general needs accommodation that would typically be offered under Part 7. And the second reason is that on my reading, paragraph 61 records that Mr. Idolo had never applied as homeless. And that is supported by paragraph 29, page 257. I read those two passages together. There's no suggestion that it was under Part 7 or could have been. So it just records that the only further step possible would be for the family to present effectively as homeless and ask for suitable temporary disability adapted accommodation. Now, of course, the provision wouldn't only be temporary if they were owed a duty, but what that refers to is that they may be moved around because they would no longer have the benefit of this secure tenancy and a permanent home. So they could be moved between different suitable temporary accommodations.
Yes, I see. Thank you very much.
Thank you, Ms McGibbon. Well, as this is a new point, and as we have counsel for the respondent in Idolo here, I think we ought to give him a chance to respond.
I think I won't be able to give evidence because I can't remember what was in all the letters. But I think the answer is at paragraph 29. That the council replied on March 14, 2019 that it was providing Mr. Idolo with a high level of daily assistance and had properly assessed and planned for his housing needs. Its adult social care and housing departments were working together to ensure that he was suitably rehoused as quickly as possible. The only further step possible would be for the family to present to the council as effectively homeless and ask for suitable temporary disability adapted accommodation. But the availability of such accommodation could not be guaranteed. Any such move might have to be for a short period only, and the housing scheme would require them to accept anything suitable without regard to their location preferences, which was an issue in Idolo because Mr. Idolo wanted to live close to his sister,
yes,
who was one of his carers. It had no access to other boroughs' housing or housing lists, and his solicitors replied saying they weren't satisfied. So the suggestion was, because it was recognised by Bromley that he was in an appalling situation, that he applied as homeless and was put into temporary accommodation. That would, of course, have been a Housing Act Part 7 solution, either under Section 188 or Section 189B. But if one then goes to paragraph 63, where Her Ladyship says, were there other housing solutions apart from waiting on the housing register, such as they were, do seem to have been canvassed. Possible short-term interim solutions were looked at, that I just referred to, including a temporary care home placement. Now, of course, a temporary care home placement would be under the Care Act because a residential care home is specifically mentioned in Section 8 as the kind of thing that can be provided, and of course under section 19, Bromley would have had, this wasn't an argument that was raised in the case, but Bromley would have had the power to place Mr. Idolo in the care home for a short period under the Care Act. It would in no way comparable to providing ordinary accommodation. It's funded in a different way. There's no tenancy agreement.
Yeah. All right. Thank you all very much. Unless my colleagues have any further questions, we will reserve our decision. We'll send it out in the usual way, that is, in the draft. 2 points about the draft. One has to say this in every case. Firstly, the draft is sent out for correction of obvious factual errors and typos and so on, not for the case to be re-argued. And secondly, it's confidential to the parties until the formal publication and handout. Thank you all very much for both your written and your oral